I'm concerned with Miss Williams' ability to comprehend what's going on because it appears to me that she is under the influence.
Hold on. Did the judge just imply that Miss Williams might be under the influence right there in the hearing? That's more than concerning. It could throw the whole case off track. What do you think? Should a trial stop immediately if the defendant isn't fully aware of what's going on?
Some substance based upon her demeanor. All right, our next case is the people of the state of Michigan versus Jennifer Lee Williams. This is case number 25-14094FH. Appearances from counsel.
And I'm Jeff Harrison. I'm here on behalf of Ms. Williams. As you may have already noted, she appears electronically from the Webster County Jail.
All right, thank you very much. Ms. Williams, are you able to see and hear the court this morning, ma'am?
Yes, sir.
Thank you. Ms. Williams, we are here today for an arraignment on a bench warrant. This court, back on August 1st, signed a bench warrant for your arrest. It was based upon an order that you would fail to enroll in drug testing as a term or condition of your probation. Of your bond for your pretrial release. Then additionally, we had a show cause for your failure to enroll in that program, and it looks like you failed to appear on that date, which was August 1st.
Contempt of court isn't some minor warning. It can land you up to 93 days behind bars or cost you $7,500. But this time, the judge offers her a lifeline, going for a bond review instead. Why do you think he decided to show leniency?
Now, when someone fails to comply with the court order, it could be treated as a matter of contempt, for which the defendant could be sentenced up to 93 days and for $7,500 in fines and costs. The court recognizes before it, also here in the back, is Alex Matson from the Western Milwaukee Community Correction Program. So, Ms. Williams, we're not going to treat this as an issue of contempt. However, the court chooses to use it as a review of your pretrial release conditions, or in other words, your bond conditions. You have the right to challenge this allegation at a contested hearing, have the prosecutor prove the allegations, which could even be done right now. So, at that you hear some witness testimony, you can cross-examine that witness. You could also present witness evidence or testimony if you chose to do so. And of course, you'll be represented by your defense attorney at that hearing. Again, the court must give you some due process. Now, if you're found to be in violation of your bond conditions, your bond conditions could be modified, continued, or bond could be revoked and could be remanded into custody.
This is where the courtroom turns into a chess match. Miss Williams can challenge the violation on the spot or hold out for a hearing, but both options come with risks. Strategy, stakes, and timing are all on the line.
Now that I've told you what the allegations are, what your rights are, and the possible consequences of your choices, I'm going to turn to Mr. Harrison. Mr. Harrison, how does your client wish to respond at this time, sir?
At this point, Your Honor, we would, in light of the fact that she's also set to be arraigned on new charges at 1:30 today, we have no option, frankly, but to do something to contest the bond violation at this juncture as well.
Okay. Well, we have a couple options here. Right now, we're at 9:50 a.m. We could proceed today to take testimony, or
I don't have my file. I didn't wish she was going to be reading up here today. I do have the new allegations.
all right.
But I was just
I don't think it'll be terribly necessary to resolve this today, Your Honor, unless the court deems it.
No, it's okay. I don't think the testimony is very complex. It might take all of 30 seconds, but the court will set it for a hearing.
I don't even have the sheet from me. I do have the new allegations. I just signed it.
That's okay.
And there it is, a meth pipe. That shifts the whole tone, doesn't it? We're no longer talking about a missed appointment or a paperwork slip-up. This is escalating into something far more serious.
So is there another allegation that she tested positive?
She had a pipe.
Oh, she had allegedly had a meth. So that will also be dealt with at the hearing. Plus, I'm going to note that I'm concerned with Ms. Williams' ability to comprehend what's going on, because it appears to me that she is under the influence of some substance based upon her demeanor and the presentation they assume.
A similar concern was raised by jail staff this morning, so I feel more comfortable not proceeding.
All right, thank you very much. I did note that Ms. Williams appeared to make a comment. I did not hear that comment. I'm going to ignore it right now because she has counsel, and counsel has spoken for her, and we will set it for a hearing. In the meantime, the court is going to deny the defendant bond and remand her in custody until the hearing. Thank you very much. We are adjourned.
Thank you.
I'm sorry, person at the jail, what is your name?
Jennifer?
Williams?
Yes.
This is case number 253631FY, the people of the state of Michigan versus Jennifer Lee Williams. We are here for arraignment. Ms. Williams, did you have the opportunity to meet with somebody from the defender's office today?
Yes, sir.
I have a complaint that alleges that on or about August 8th, 2025, in the city of Cadillac of Wexford County, in count number 1, it is alleged that you did commit the offense of possession of methamphetamine. That is a felony.
Let's break this down. Meth possession, assaulting a police officer, and now being labeled a habitual offender. That last part, it means tougher sentencing. Things just went from bad to worse, fast.
Punishable by up to 10 years in prison and or a fine of $15,000. In count number 2, it is alleged that you did commit the offense of police officer assaulting, resisting, or obstructing, in particular Sergeant Zach Hicks of the Cadillac City Police Department. That is a 2-year felony, punishable by up to 2 years in prison and or $2,000. Consecutive sentencing may be imposed if it happened in place of confinement. In count number 3, it is alleged that you are a disorderly person who was found jostling or roughly crowding people in a public place. That is a misdemeanor, punishable by up to 90 days in jail and or a fine of $500. In count number 1 and count number 2, the prosecution has also elected to charge you as a habitual second offender. That means that you have at least one prior felony or attempted felony in your past. That makes the 10-year felony and 2-year felony punishable by 1.5 times that amount. Do you understand those charges and potential penalties?
Yes.
You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, and historically I show a jostling in 2019, domestic violence in 20, in 24 larceny less than 200, in 24 an attempted resist and obstruct. There was a 4A case back in 17. In 06 there was an MIP of alcohol, 22 an operating while visibly impaired, and 25 a trespass. It's my understanding that she has a bond violation out of the circuit court for I think it was a drug charge and possession of contraband, if I remember correctly. My probable cause affidavit that I read today indicates that she was maybe in absconder status in the circuit court, and I know there was a bond arraignment, a bench warrant violation arraignment today, in which was set for a contested hearing, if I remember correctly. Probable cause affidavit also indicated that looks like there was an attempt to apprehend her by the bounty hunters, so to speak, looking for her. Any comment regarding bond defender's office?
I apologize. I wanted to make the court aware that the circuit court I was informed on the circuit court did not accept any plea from her today because she appeared to be under the influence of something. I spoke with her about an hour ago, and that didn't strike me to be the case. So I just wanted to make that statement.
I will state for the record, I did watch her arraignment this morning via the live stream because I was curious what was going to happen. And it did appear that, to me, it looked like she may have been nodding off at times, but I'm not sure about that, so I can understand where the court was coming from with that. But
I will just say I would be comfortable with the state of mind that she was at least an hour ago and proceeding to I would like to say that the incident, at least where she was picked up here, I feel such mentioning because I found it sort of uniquely a way to get arrested. Was her baby's father more or less tricked her into thinking that she was going to see the child for the first time in 3 years, and she got arrested. So I thought that kind of sucked. Not that didn't have bond in any way.
is that from when they were trying to apprehend her for her bond violation?
I believe so.
The bondsmen were trying to apprehend her?
Yes. That being said, she does have a support network that's strong here in the city. She has a partner who she would like to stay with. She also has I wouldn't say a job lined up, but work lined up at a house that she can stay in. So that would also take her a house. She wasn't able to give me the address for that, but it did sound incredible.
I should have also mentioned that the praxis scores her at a risk level 8, which is a high risk. Is there anything about that you want to address? I know you already addressed the housing issue and the lead on work.
No, you're wrong.
Ms. Lawrence?
You're right. I don't think I need to go into too much detail. As the court stated, they read the affidavit on this case. I think it's pretty clear the defendant cannot be successful on bond, since she is on bond in circuit court for another possession of meth, and she picked up this new possession of meth while on bond. And also clearly here in circuit court as well. Given that, and also the fact that this did happen in a public place, very busy place, at GMD Party Store in the parking lot, I do think there are some concerns for public safety in this case. I would ask for random drug testing as well as a $10,000 bond.
What was her bond in the circuit? Do you remember?
I believe I was told she had a
No, but before she absconded. In my mind, I thought I had changed her previous bond to $25,000. All right, the court finds that
This is the courtroom version of hitting the brakes hard. The judge doubles her bond and adds a GPS tether. Is this justice taking control, or the system scrambling to catch up to a runaway case?
Ms. Williams presents as a flight risk in that she was absconding from circuit court bonds, and by the praxis, it looks like for over a month, and that she had failed to enroll. I assume that's the testing. At least based on the findings of the probable cause affidavit that I had to review in order to find probable cause for the charges today, it does appear that she was trying to be apprehended by the bondsman's bounty hunters, and it was not going so well for Ms. Williams. So I do find that she is a flight risk. I also find that she's a threat. I am going to order a $50,000 cash or surety bond, since the $25,000 didn't keep her coming back to court or following bond conditions. Ms. Williams, you are to appear as ordered to keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also going to order that you not consume any illegal controlled substances, including recreational marijuana. You'll be subject to random testing. On the situation that you are released from jail, I'm going to order that you be placed on a GPS tether for location purposes only. Ms. Ejimera, anything else?
No, you're
All right, we're adjourned. Thank you, jail.
Thank you, Your Honor. Have a nice day.
You too.